What's going on, everybody? So I'm actually doing a video on the chain of custody of the R. Kelly sex tape. Now, just to let everyone know, there was a trial in 2008 which they had a sex tape of R. Kelly. I am not sure if that is the same sex tape or one of the same sex tapes that's being used in the current litigation against R. Kelly, right? Everyone knows that Avenatti came up with several sex tapes, and basically he gave these sex tapes over to his Illinois State's Attorney Kim Fox, and that's what this video is basically going to be based on. Now, whether or not these are the same sex tapes that are going to be used in the federal trial, I don't know. I believe so. Right. So with that said, we're going to take a look at the federal rule that basically governs evidence. I'm pretty sure there's a state rule that governs evidence, but for the most part, I think the federal rule is going to trump the state rule, and it's probably going to be similar to the state rule. So I just thought we killed two birds with one stone by looking at the federal statute, right? So the federal statute in question is 28 USC Federal Rules of Evidence 901, authenticating or identifying evidence, right? So basically, Rule 901 goes on to say, in general, to satisfy the requirement of authenticating or identifying an item of evidence, the proponent, the prosecutor, must produce evidence to support a finding that the item is what the proponent claims it is, right? And then it goes on to say B, examples, right? The following are examples only, not a complete list of evidence that satisfies the requirement. Basically, these are some quick examples, but it's not a complete list, right? So the first example, one, is testimony of a witness with knowledge, right? Testimony that the item is what it claims to be, right? So I believe what they're going to do is that they're going to have the victims come forward, and they're going to have the victim say, yes, that's me and the sex tape, right? And then two, non-expert opinion about handwriting, right? A non-expert's opinion that a handwriting is genuine based on the familiarity with it was not acquired from the current litigation, right? And then three, comparison by an expert witness or a trier of fact. A comparison with an authenticated specimen by an expert witness or the trier of fact, right? So I think three is basically where they bring in a forensics expert or expert in a certain subject matter. They're obviously going to try to bring in expert witness, that are going to try to claim that the tape hasn't been altered. And then R. Kelly's lawyer is obviously going to bring in expert witness to say that the tape has been altered, right? And then it goes on distinctive characteristics and the like. The appearance, content, substance, internal patterns, or other distinctive characteristics of the item taken together with all the circumstances. So 4 really isn't going to apply. 5, opinion about a voice. This is not going to apply anyway, but since we're reading statutes, we may as well read it. An opinion identifying actually it could apply, I don't know. An opinion identifying a person's voice, whether heard firsthand or through mechanical or electronical transmission or recording based on hearing the voice at any time under the circumstances that connected it with the alleged speaker. So to me, on first hand, it seems like it wouldn't apply, but they may try to bring someone in to try to tie R. Kelly to the sex tape based on his voice. It would be pretty ridiculous if they did, but it's in the statute, so you can't rule it out, right? 6, evidence about a telephone conversation. This definitely isn't going to apply, but we're going to read it anyway. For a telephone conversation, evidence that a call was made to the number assigned at the time to a particular person if the circumstances include self-identification, show that the person answering was the one called, or B, a particular business if the call was made to a business and the call related to business reasonably transacted over the telephone, right? And then 7, right, it talks about evidence about public records, evidence that a document was recorded or filed in a public office as authorized by law. Doesn't really apply. B, a purported a purported public record or statement is from the office where the items of this kind are kept, right? Neither of those apply. 8, evidence about ancient documents or data compilations for documents or data compilations, evidence that it A is in a condition that creates no suspicion about its authenticity, right? And then B was in a place where if authenticated or authentic, it would likely be. And C, it is at least 20 years old when offered, right? So this very well could apply, and I think it's going to speak towards the authenticity of the tape, right? Because basically you have this old tape, and they have to find a way to prove that it's authentic. And basically the tape has to be in a condition that doesn't create suspicion about its authenticity, right? So, in my opinion, that's going to be pretty difficult to do in this situation, right? Because of the chain of custody it actually came. First off, we don't know who had the tapes before Michael Avenatti. Second, Michael Avenatti is being currently accused of fraud. So the chain of custody of the tape is definitely going to be questioned, and R. Kelly can come out and say, "Hey, I've never seen that tape before."